Let's look at a few of the essential elements of the DMCA, and we'll see how that's applied to the same fact pattern. I tried to distill out some of the most significant issues of the DMCA and interpret them into plain English. I have my copy here of the DMCA, and I printed out my copy. I sent a copy electronically to Professor Lewis. I don't know if any of you had a chance to read it. If you did, you probably, I'm sorry, my apologies. My apologies. The DMCA, I printed out my copy. It's about 8 pages in small type. It's codified as part of 17 U.S. Code. That's the Copyright Statute, Section 1201. And it's not exactly something to crawl up to a warm, crackling fire with on a cold winter night, unless you want to stoke the fire. I try to distill some of the sections out and interpret them into plain English. If I have to go through some section of the statute, bear with me. I realize that sitting there watching someone read sections of the U.S. Code can be about as exciting as watching grass grow, like the green kind on the lawn, but bear with me. Let's see if we can get through it. The first section provides no person shall circumvent a technological measure that effectively controls access to a copyrighted work. Now, in plain English, that prohibits the electronic equivalent of breaking into a locked room in order to obtain a copy of a copyrighted work. And A2A forbids a person from manufacturing, importing, offering to sell, or traffic. Notice that term traffic. I bolded the word traffic. In any technology that is primarily designed or produced for the purpose of circumventing a technological measure that effectively controls access to a copyrighted work. That prohibits trafficking. Note, if you will, the word trafficking. That implies distribution, even not for profit. Someone does it without even making money, but just traffics in technology. It prohibits trafficking in technology and how to unlock the lock that locks the room in which the copyrighted work is stored. Now, the statute defines a few things, like to circumvent a technological measure. In plain English, that means to decrypt an encrypted code of encoded work without permission of the copyright owner. Another term that's used is a technological measure that effectively controls access to the work. That means that the copyright owner has to treat the technology like a trade secret. So, in order to be protectable under the DMCA, the work must, number one, be copyrightable subject matter. We talked about some of the basics of copyrights. Number two, it has to be in encrypted code, such as an encrypted code for a DVD. And number three, the copyright owner must use a measure that effectively controls access to a copyrighted work. That's like applying trade secret type of protection to the copyrighted work. Now, notice, if you will, that the DMCA effectively provides trade secret type of protection for copyrighted works that are encrypted, notwithstanding the fact that the secret encryption system was decrypted by reverse engineering. Now, this has raised the ire of some people, notwithstanding the 3 scholars who wrote this book, because there are certain issues involving First Amendment freedom of speech. Under the First Amendment of the Constitution and under the Constitution of many states, there is a provision that Congress shall make no law abridging freedom of speech. Well, that's almost a one-liner. Seems much easier than having to read the DMCA. It's complicated. For example, we know since an early age that you can't yell fire in a crowded theater if there's no fire. The FCC forbids the networks from using, I think it's 7 so-called obscene words on the air. If you analyze them, they're guttural and colloquial references to carnal and bodily functions and parts, which are rather normal. It's ironic that the FCC permits the networks to use truly obscene words like war and homicide and genocide. Go figure. Okay, let's look at how the DMCA is applied to the same fact pattern. And the case is this case was the application of the DMCA when the motion picture industry filed lawsuit against Eric Corley and a number of other hackers based on the Digital Millennium Copyright Act. They filed it in federal court. All copyright cases go to federal court. They filed it in the Southern District of New York, in federal court down there in Foley Square. And this time they named names. Instead of just picking everybody by picking up a list of all the defendants and identifying them alphabetically, they went after the target defendant. This time they identified Eric Corley. There were a number of others that were identified, but he was their target. I guess it's because Eric Corley is one of those who was more in your face to the motion picture industry, who was distributing DCIS. Eric Corley is a rather colorful person in the hacker community. He's viewed as a leader of the computer hacker community, and he goes by the name of Emmanuel Goldstein, who is the leader of the underground in George Orwell's classic novel, 1984. He has a company which is named 2600 Enterprise. And I think 2600 is some information that you could use to hack into some early telecommunication systems. He publishes a publication called 2600, The Hacker Quarterly, which he founded in 1984. His publication has some interesting articles like how to steal an internet domain name, how to access other people's email, how to break into the computer systems at Costco, how to break into the computer system at Federal Express, a guide to the federal criminal justice system for readers charged with computer hacking. And just to prove how much unmitigated gall he had, he copyrighted his magazine and other material on his web to prevent others from copying his magazine. Well, okay, Eric Corley was sued, and by the way, this time all of the defendants had a lot of people who were filing what was referred to as amicus curiae. That means friends of the court brief. They weren't necessarily friends of the court. They were just friends of one side or the other. So there was a lot of people on both sides. Eric Corley wasn't sitting there defenseless against a major motion picture establishment, sir.
Was all that other stuff illegal?
Oh, pardon me?
That is to say, was it illegal for him to publish instructions on how to break into those various places?
I haven't read the articles, and the court, in fact, didn't even mention that he was convicted, at least to the best of my knowledge. You know, there probably is more facts, like what he tried to do. It more be.
I'm a little worried about my demonstration of how to crack the four-cylinder bicycle lock.
Okay. When we say illegal, it may have been more aspirational than operational. We don't know that from the opinion, but I think that if there was a conspiracy to commit a federal offense, it could be illegal. There has to be a very high level of intent for there to be a conspiracy.
He's just trying to provide public enlightenment.
That's what he said, okay? I can tell you that Costco and Federal Express did not think that he was providing public enlightenment. There's two sides of the story, depending on what side of the courtroom you're sitting on. Anyway, though, he went into the motion picture industry, which was named in the litigation. They named most of the major players like MGM, Universal Cities, Paramount, TriStar, Disney. And when it came to the amicus curiae, the friend of the court brief, the NFL filed a brief on behalf of the plaintiffs. The NFL tries to file the briefs in these cases always on behalf of the plaintiff. The NFL is about as aggressive in protecting its intellectual property rights as its players are in playing the game on the field. Well, they went into court to seek an injunction. And the motion picture industry had to prove the essential elements. They proved that it was copyrighted works. They proved that they encrypted it. They proved that it was decrypted and that Eric Corley distributed it on the web. One of the defenses that he asserted is that they did not try to effectively control this technology simply because it was decrypted. His argument was, well, if this could be decrypted, then the motion picture industry did not meet their requirement of making efforts to effectively control it. Well, taken to its logical extreme, that would mean that if you don't need protection under the DMCA, you get it. But if you do need protection, you don't get it. The court made a finding. They analyzed some of the evidence. Some of it was in camera, just so as not to publish it in the opinion as to how much work he did and what the specifics are. But the court made a finding that the motion picture industry did try to effectively control this technology by